All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Harris, Senator Dondero Loop, Senator Orenshaw, Senator Wynne, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, thank you so much. We have one bill on for a hearing today and everything else on for work session. Our amazing staff has been working around the clock as I send them copious emails with imprecise directions to add amendments, remove amendments, and amend amendments. And so they are actually still working on the work session document as we speak. But I know we have other committees that need to go today and didn't want to get too far behind. So we'll go ahead and start with the bill hearing. After the bill hearing, we'll kind of check in. We may take a brief recess to go over the work session document. Get everybody a copy of the work session document and come back, or we may go directly into work session. We'll just see how we feel. And with that, I will open up the hearing on AB 101.
Good afternoon and happy deadline day. Good afternoon, Chair Scheibel, Vice Chair Harris, and members of the committee. For the record, my name is Assemblywoman Cecily Gonzalez, representing Assembly District 16 in the Nevada Legislature. With me today is Nathaniel Erb, the state policy advocate of the Innocence Project, and I will kick it to him after my brief remarks. In 2019, the legislature passed Assembly Bill 267, which provided compensation for those who are wrongfully convicted. When DeBarlo Berry went to prison in 1994 for a murder he did not commit, it was a jailhouse informant that was the incriminating witness. Based on the informant's testimony, Mr. Berry was convicted and sentenced to life in prison. And in 2004, the informant admitted that he had lied and also received benefits for his false testimony. Testimony from jailhouse informants was one of the leading contributors to wrongful convictions, as we have spent a plethora of time talking about that in this committee, and plays a role in nearly 1 in 5 of the 367 DNA-based exoneration cases nationally. So who's an informant? An informant is an individual who provides testimony or information about statements that the defendant has made while they were incarcerated together. Informants often receive benefit from prosecutors for information, usually in the form of plea bargains or reduced sentences on their own criminal charge or by dismissal of their case entirely. At the very least, the use of jailhouse incentives can be a distortion to our criminal justice system, and more importantly, the unregulated jailhouse informant testimonies can and has sent innocent people to prison. We've worked extensively with the district attorney's office and the public defender's office, who will testify later to the work that we've done on this bill. And so with that, I'll do a short walkthrough, and then I will kick it to my co-presenter, and then we'll be ready for questions. Sections 2 through 5 provide definitions. Section 6 provides that the office of a prosecuting attorney must maintain complete and systematic records for any case prosecuted by the office for which testimony or information was provided by an informant pursuant to a cooperation agreement. Section 7 provides that if a prosecuting attorney intends to use an informant's testimony or information at a hearing or trial, certain information or materials must be disclosed to the defense as soon as possible, but no later than 30 days before the trial. In Section 7, subsection 3, the court may order disclosures to only be made to the attorney of the defendant and not the defendant or any other party if making the disclosures may result in substantially bodily harm to the informant that is incarcerated. And lastly, in Section 7, subsection 4, a court is required to instruct the jury to consider certain information in assessing the credibility of an informant. Chair, with your permission at this time, I will turn the presentation over. Thank you.
Good afternoon again. For the record, my name is Nathaniel Erb. I'm here on behalf of the National Innocence Project to speak to you about this bill. We have been working across the country on this issue for many years. There have been over 180 wrongful convictions to date that have involved the use of jailhouse informants whose cooperation and benefits they received were not turned over, as well as the impeaching information related to what is constantly required to be turned over to the defense not being turned over. as a result, prosecutors across the country have been working on how do we address this issue with our own offices. This policy has its roots back in district attorneys' offices in Texas, who sought to set up systematic record keeping for their own offices so that they know what type of deals are being cut amongst informants across the state, so that if one informant is getting a deal from one office, other offices know about that, especially if there's a breakdown, if there's a credibility issue, that they can rely on individual offices to share that information with one another and make sure they're putting forward the best type of witness. And second with that is making clear, what does the Constitution actually require in terms of information that needs to be handed over? So what are the types of materials that lead to the credibility of a witness that is constitutionally required to be handed over to the defense in order to prevent a constitutional claim on appeal or any other issue in the criminal case. So we have been working on this bill for a number of years. The District Attorney Association actually proactively started adopting a lot of these policies on their own volition after seeing the issues caused by wrongful convictions here in Nevada. And then over the last couple of years, we were working closely with them, and a major shout out to the association collaborating on this bill to put forward looking at the policies that are already in place, how do we make sure that those are maintained as a good practice going forward, and that there's clarity across the state of what needs to happen. So this bill would have a little bit narrower focus than some other states. It would only require record keeping within offices, whereas some states require a statewide tracking database. So just make sure that the information offices already have on these types of informants is housed and kept so that it can be used in future criminal investigations and criminal cases. And then secondly, it just specifies the types of information that needs to be handed over to the defense as is constitutionally required in order to prevent a constitutional violation. Also, the bill itself is limited to only when an informant is testifying at trial. Some other states require providing information if the informant offers to provide testimony or if they're just providing background information, whereas this bill would only apply to an informant who actually testifies publicly at trial. So their identity would be known. It would be completely separate from the issue of a confidential informant, that their identity wouldn't be hidden. And a third piece to it is there's actually an additional safety valve in the bill that doesn't exist in current law, which allows a judge that if there's any question over the information that an informant that needs to be handed over about an informant, that information isn't constitutionally required and could trip up a safety concern, there's the ability of the judge to withhold that information from the defendant and only provide it to the defense attorney if the judge feels that information is still necessary to hand it over. I really doubt that piece would ever happen. A couple other states have that same safety valve, and we've never seen it actually required to be used because the information is always required under constitutional law, but it's an extra protection that's put in place. So it's a pretty straightforward policy and practice that just continues what's already happening here in Nevada. And with that, I will turn it over to Professor Jency Anderson, who can talk about the specific cases here in Nevada.
Good afternoon, Chairman Scheibel, Vice President Harris, Vice Chairman Harrison, and the members of the committee. Thank you so much for giving me a moment to speak on this bill. I am a professor at the University of Utah College of Law, where I teach innocence law, as well as post-conviction law, as well as legal writing. And I was one of the lead attorneys on the DeMarlo Berry case. And so I just wanted to address the importance of AB 101, and thank you so much for hearing it today. Almost 7% of the cases on the National Registry of Exonerations involved a jailhouse informant, who lied and sent an innocent person to prison. The use of jailhouse informants is a leading cause of wrongful conviction and is the leading cause of wrongful conviction in death penalty cases. And this isn't just a national problem. At least 15% of the recorded exonerations in Nevada involve a jailhouse informant. And AB 101 goes a long way in addressing this problem. But the main reason I was asked to speak here today is because I was deeply involved in the exoneration of DeMarlo Berry. He couldn't be here today, but I was asked that I tell you a little of his story. And I think his story is the perfect way to illustrate why AB 101 is so important. So in 1994, DeMarlo Berry was sent to prison in Las Vegas for a murder he didn't commit. There was no physical evidence that connected DeMarlo to the scene, and there were 13 eyewitnesses who saw the murderer escape, but only one of those 13 picked DeMarlo from a photo lineup. While DeMarlo was in jail awaiting trial, an inmate claimed that that DeMarlo had confessed to him while he and DeMarlo were in a holding cell together. In exchange for his testimony, this inmate was given leniency on cases that were pending in both Washoe and Clark County, cases that would have put him in prison for a long time on a 3 strikes charge. In addition, the inmate who had been extradited from Ohio to face all of his Nevada charges was also awarded several trips back to Ohio to be with his dying father, as well as room, board, compensation, and trips to Las Vegas for trial preparation and for trial. Because there was almost no other evidence presented against DeMarlo, it was based on this informant's testimony that DeMarlo was convicted and sentenced to life in prison. In 2014, after the actual perpetrator, Stephen Jackson, confessed, the informant admitted that he had lied about Barry's confession. It's important to note that none of the information about the benefits that this informant received from the prosecutors was disclosed to defense counsel. After fighting DeMarlo's case for 4 years, in 2017, the newly formed Conviction Review Unit in Clark County District Attorney's Office agreed to declare the charges against Barry dismissed, based upon the Regional Innocence Project's investigation, the confession of Stephen Jackson, and the informant's recantation. In 2020, the court issued Barry a certificate of innocence, finding that he was factually innocent. He was also awarded compensation for the almost 23 years he spent in prison, and recently settled a civil lawsuit that involved issues surrounding the informant's testimony. DeMarlo's case emphasizes how important AB 101 is because, first, jailhouse informants are inherently unreliable. In other words, some of them lie. They lie to get benefits, they lie to get leniency, they lie. Some may be truthful, but we know from experience that many of them do not tell the truth. We also know that because often the benefits they receive is hidden, the potential to convict the innocent is real. It's happened 4 times in Nevada and at least 200 times nationally. And not only do jailhouse informants result in wrongful convictions, it can also result in constitutional violations, like the violation of the Brady case, which requires prosecutors to turn over exculpatory evidence if they have it. And finally, and I think this is really important to note, the use of jailhouse informants can hurt victims. No justice is served for the victim when the innocent are convicted. The criminal justice system can also fail the victim when a defendant receives benefits in one case in order to get leniency in another. Marcy's Law demands that victims are treated with more respect, and AB 101 recognizes this. For all of these reasons, for the protections that are built into this law, the hard work that's gone into this law, the amazing and invaluable support of the District Attorneys Association, we would ask that you join other lawmakers across the country and pass AB 101. Thank you so much.
Thank you so much for your presentation. I also have to apologize for laughing on the dais. It was nothing to do with what's going on in the presentation. It has to do with the work session documents and how amazing our staff is and how incredibly grateful I am to them. So with that, we will open it up to questions on AB 101. What? Senator Wynn.
I love the bill. That's it.
All right. I guess we'll go to testimony then. In support of AB 101. We'll start in person in Carson City. I don't see anybody in Las Vegas, but if there is somebody hiding in there, please come up to the microphone now.
Good afternoon, Chair Scheibel, Vice Chair Harris, and members of the Senate Judiciary Committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. It has been our pleasure to work with Assemblywoman Gonzalez and the Innocence Project, in particular, Mr. Erb, on this bill. We think it's good policy and will ensure that from administration to administration, tracking consistent with Brady and Giglio are done, and that any discovery required under the Constitution is provided. Thank you. We're in support of the bill.
Good afternoon, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office. I believe that was probably the first time that we have sat next to each other this session, and so I think that means you're required to pass the bill, and we're in support. Thank you.
Thank you, Chair. John Pure from the Clark County Public Defender's Office. I'd like to thank Assemblywoman Gonzalez, my friend Mr. Erb, for bringing this bill forward. Glad that we could work with the district attorneys this year. We thank Jennifer Noble for working on this hard to move this bill forward so that we could finally get this one done. Thank you.
Tanya Brown, Tonja Brow, and good afternoon. We strongly support Assembly Bill 101. It's long overdue, and someone who has been personally affected by someone from the DA's office who withheld exculpatory evidence regarding a state's witness, I can say that hopefully this bill will prevent that from ever happening again. In our particular case, we have presented you the handwritten notes of the prosecuting attorney in which it talked about the credibility that was never turned over. Let me just tell you what was found in that file, okay? There was information that pertained to the state's witness being a secret witness, that they knew that she had committed some crimes. And most importantly, that she had trouble identifying Mr. Klein's voice from someone else. But she would become the expert witness for the state to go into court and say, that's his voice. Nobody got to listen to the tape recording of a comparison of his voice and the other. And I will tell you that even during the post-conviction proceedings, when it was against the ineffective assistant of counsel, during her testimony, she stated that she did not believe that the tape recording of the 911 call sounded like her client. And don't you think the jury would have concluded that? But there was so much more about the credibility of the state's witnesses, and being she was also the informant to the police. We strongly support this bill. It is long overdue. Thank you.
Thank you. I don't see anybody else here to give in-person testimony, so we'll go to the phones for support testimony on AB 101.
Thank you, Chair. If you would like to offer testimony in support of AB 101, please press star 9 now to take your place in the queue.
Hello, my name is Yesenia Moya, Yesenia Moya, and I am a local community member down in Las Vegas, Nevada. I want to thank the Assemblywoman for bringing this forth, and I really, really want to support this, so if you can please pass this bill. Thank y'all so much.
If you have just joined us and would like to offer testimony in support of AB 101, please press star 9 now to take your place in the queue. Caller with the last 3 digits, 115, please press star 6 to unmute yourself.
Hello, my name is Brian Harris, and I'm calling in support on behalf of my organization, Battle Born Progress, we would like to ditto the comments of the previous members who testify in support of this bill, and thank you for your time.
There are no further callers to testify in support at this time.
All right, then we will take testimony in opposition to AB 101. I don't see anybody coming forward to give opposition testimony in person, so we will go to the phones, please, for opposition to AB 101.
Thank you, Chair. If you would like to testify in opposition to AB 101, please press star 9 now to take your place in the queue. There are no callers wishing to offer opposition testimony at this time.
All right, then we'll move to neutral testimony. Anybody wishing to give neutral testimony in person? Now is the time, but I don't see anyone, so we will go to the phones for neutral testimony, please.
Thank you, Chair. If you would like to offer neutral testimony to AB 101, please press star 9 now to take your place in the queue. There are no callers wishing to offer neutral testimony at this time.
All right, then that brings us to the conclusion of testimony. If the bill sponsor has any closing remarks or comments, all right, then that will close the hearing on AB 101, and I would accept a motion to do pass. All right, there is a motion from Senator Orenshall, a second from Senator Krasner. Any discussion on the motion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. It is a unanimous vote to do pass AB 101, and I will assign this floor statement to Senator Wynn.
Thank you so much, Chair. I really appreciate the floor statement on this one.
You're very welcome.
Thank you for signing it. Chair, may I make a comment, please?
Please.
I just really want to thank you for not giving me the floor statement. And because that means I don't have to stand up on the floor, but I want to tell you what a wonderful chair you have been all session long. And I thank you from the bottom of my heart.
Well, thank you, but we're not done yet. We have a work session, everybody. And so I do see that some of our bill sponsors are here on their work session items. So I'm going to go ahead and move to the work session. As I indicated, we were still working out some of the paperwork with amendments and bill explanations and things like that. So please don't take it as a sign of anything if we skip something or move around. It just means that I'm still catching up. But I think we are good to go ahead and start with our consent calendar. Actually, I think we're going to divide these out instead of doing a consent calendar. Let's just go ahead with AB 231. If we're not doing a consent calendar, that's a really weird order to go in, isn't it? Let's start with AB 49.
Okay. Thanks, Chair. For the record, Patrick Guinan, Committee Policy Analyst. So AB 49 is the first bill listed in the document that's not on the consent calendar for those who are following along. This is a bill presented by the Assembly Judiciary Committee on behalf of the Attorney General. Excuse me, we heard it here on May 10th. And AB 49 prescribes separate and distinct forms for a petition for writ of habeas corpus that challenges the computation of time that a person has served pursuant to a judgment of conviction, and a petition for writ of habeas corpus that challenges the validity of a judgment of conviction. The bill also repeals the requirement that the respondent file a return with the court, and instead requires that the response or answer be filed by the filed by the respondent include the information contained in a return under existing law. And finally, the bill makes mandatory provisions applicable to a post-conviction petition for writ of habeas corpus filed on or after July 1 of 2023. The Attorney General's office proposed an amendment at the hearing that's attached for review. It provides that if a petition for habeas corpus challenging a judgment of conviction or sentence is denied, the petitioner must not be released on the petitioner's own recognizance or admitted to bail pending any appeal. There's an additional amendment which is just here from Senator Wynn, and I'm sure she can explain it further if the committee wants her to. It proposes an additional amendment to authorize the service of certain legal documents related to criminal cases and post-conviction petitions by electronic means. That's all, Chair.
Rochelle, do you want to, excuse me, Senator Wynn.
That's my name. It's okay. Thank you, Chair. And I wanted to thank the Attorney General's office for allowing me to propose this additional amendment. I know that with a lot of these habeas petitions, and just to make things particularly clear, on here it says authorizes service, and we would like to authorize in just its permissive language for filing and service, if that's possible. And so I guess I would make an amendment to that amendment. And this just allows that if Team Tablet crosses the finish line and there is the possibility for electronic filing and service as opposed to paper copies or fax machines or any of those kind of things, that this enables that type of service and filing for habeas petitions. And so if anyone has any questions about that, that was the intent, and that is what that is. So filing and service.
And you may have said this, but we did talk to the Nevada Department of Corrections about it. It wouldn't be a financial impact because it would be as they're able to do that.
That's correct. Right now, people that are incarcerated that are filing these petitions for habeas corpus have to physically pay for all the filing, like not the filing fees, but the copy fees, which are about 10 cents a page, and they have to make about 5 copies of these documents and mail them regular mail. Whereas in most things we've modernized and there's an electronic filing and service system. And so if this is available in the prisons, which I know they would like to do this gives them the opportunity to be able to do this, but we do need that statutory change.
All right. Thank you. Any other questions on the bill or the amendment? All right. Seeing none, I would accept a motion to amend with the Attorney General's proposed amendment and Senator Wynn's proposed amendment as outlined today in our discussion.
I'd so move.
Second.
All right, we have a motion from Senator Wynn, a second from Senator Orenshaw. Any discussion on the motion? All right, not seeing any. All in favor, aye. Aye. Any opposed, nay. We have a unanimous vote to amend and pass Assembly Bill 49. I will assign the floor statement again to Senator Wynn. And with that, we will move to Assembly Bill 121.
Thanks, Chair. Assembly Bill 121 is sponsored by Assemblywoman Considine and others. It was heard here on April 19th. It relates to incarcerated persons. AB 121 requires the Department of Corrections to provide an offender with the original physical copy of any mail addressed to the offender that they are entitled and allowed to receive. And the department and city or county jails and detention facilities are required to provide notification within 24 hours to certain persons concerning an incarcerated person's critical medical condition if the incarcerated person was required to stay in a medical facility overnight. If the incarcerated person's medical condition does not require an overnight stay in a medical facility, that person must be provided an opportunity to make a telephone call to a friend, relative, or other person regarding their health status within 4 hours after their return to the facility where they are incarcerated. And lastly, if an offender requires prescription medication, this bill requires that the prescription be filled in a timely manner. There is an amendment proposed by Assemblywoman Considine to the bill, and it is as follows. You would add new language to Section 2 of the bill, providing that if the Director of the Department of Corrections determines through a study of factual evidence, data, and/or documentation that providing an original physical copy of mail presents a danger to staff, offenders, or other persons, the Department will report such findings and any recommendations to the Board of Prisons and to the Director of the Legislative Council Bureau for transmittal to the Standing Interim Committee on Judiciary on or before October 1 of 2024. To ensure that all regulatory requirements are followed, no administrative changes or operational changes shall be implemented by the Director or the Department regarding the provision of mail to an offender prior to the submission of that report. That's all, Chair.
Thank you so much. Do you guys have questions on the amendment, or do you want the sponsor to come up and Why don't we have the sponsor come up and give it a little overview, because it is a change from what we discussed in committee. I've had the benefit of getting to talk to Assemblywoman Considine since that hearing, but I don't know that all of you have. So please go ahead, just give us a brief summary.
Thank you, Senator. So this was an amendment that just came in recently, and it was in conversations with Return Strong, who had conversations with the Director of Corrections, and this was a way to try to find a balance to give the Department of Corrections time that if balancing the safety of the inmates and the staff, as well as balancing the mental health and physical health of the offender, and this was the language that was agreed to. And I can answer any questions about that, but Senator, if I may, if it is appropriate for me to mention something else. There was another amendment that was sent on May 3rd that included Senator Wynn as a co-sponsor, as well as defined one of the words in here, and I don't see it on the work session documents.
Why don't you tell us a little bit more about what the amendment would have done?
Okay, so the amendment, as it was sent, Section 3, Sub 4A4, and Section 7 added a definition of extreme physical illness. This was requested. So the way that this is set, I'll read it verbatim, NRS 453C.050 and NRS 453C.150 sub 5 include a description of extreme physical illness relating to an overdose. The language differs slightly between the two provisions, but is considered a condition including a decreased level of consciousness, respiratory depression, coma, or death resulting from a drug or alcohol consumption that an ordinary layperson would reasonably believe to be an overdose that requires medical assistance. So this was a request that was done from some of the Metropolitan Police Department in Washoe. So I don't know if it's possible to add that at this part, but I did not want to walk away without bringing this up.
Completely fine. So we can definitely add additional amendments right now, and I think that sounds very reasonable. It's not a great departure from anything that we've already discussed. My members may want to see it in writing, or okay, it sounds like they have some questions for you. So I'll hand it first to Senator Hansen.
Thanks. Not so much the first amendment you mentioned. Now, is Director Zorinda now on board with the bill? You indicated that you guys worked something out, so I just want to make sure. I don't see anybody from corrections here, unfortunately.
Thank you, Senator Hansen, for the question. Through Chair Scheibel, Vanish Consign for the record. This language was discussed between Return Strong and the Director Zorinda. I have not had a personal conversation with Director Zorinda about this, but from my understanding, he approved the language. I have an email saying that he is good with this language.
Very good. Thank you.
Thank you.
Other questions? All right. Not seeing any other questions, I would accept a motion to amend with both the verbal amendment put on the record by Assemblywoman Considine just now, as well as the amendment that is contained in conceptual form on the work session document. All right, we have a motion from Senator Orenshaw, a second from Senator Wynn. Any discussion on the motion? All right, all in favor, aye. And any opposed, nay. All right, motion passes unanimously. And I will assign the floor statement to Senator Orenshaw. And we're going to take like a 1-minute recess. right, we will come back to order and go on to Assembly Bill 193.
Slowly. Thanks, Chair Pat Guinan. So we are now on Assembly Bill 193, which was sponsored by Assemblymember Gonzalez, who happens to be here. This bill relates to custodial interrogations of children. And we just heard the bill yesterday, so I don't know that I need to go through a lengthy summary, Chair. If you want, I can. There is an amendment I can discuss, though. The amendment is attached for review, and it does the following two things. It moves the provisions of the bill to Chapter 62C of NRS, which pertains to the rights of minor children in the custody of law enforcement, and it clarifies that the provisions of this section apply to a minor child who is later certified as an adult pursuant to NRS Chapter 62B. And that's all I have on this. Do you want to go through the bill?
All right. Any questions on the bill or the amendment? Senator Krasner.
Thank you, Chair. One amendment, I asked if Assemblywoman would be kind enough to allow me to sign on as a co-sponsor.
Yes. Thank you.
All right. Any other questions? Not seeing any. I would accept a motion to amend and do pass. Okay. I'll take the motion from Vice Chair Harris, the second from Senator Krasner, and any discussion on the motion. Not seeing any. All in favor, aye. Aye. Any opposed, nay. I think that is one nay from Senator Stone. And I will assign the floor statement to Senator Harris. Thank you, Chair. You're welcome. And that takes us to AB 340. Thank you, everybody. We are going to do AB 309. It was on the consent calendar, and then when I broke them apart, it got out of order. So we'll move to AB 309 next.
Thanks, Chair. Pat Guinan for the record. AB 309 was on the consent calendar. There are no amendments. AB 309 is sponsored by Assemblywoman Hanson. And we heard it here just yesterday. AB 309 authorizes the use of secret electronic ballots for the election or removal of members of the Executive Board of a Unit Owners Association of a common interest community and for the election of delegates or representatives to exercise the voting rights of unit owners in such an association. It provides that a member of the Executive Board who is the subject of a removal may submit a written request for a meeting of the Executive Board at which the removal will be discussed as an agenda item. Notice of such a requested meeting must be given to the unit's owners within 5 days after the receipt of the request. The bill requires an association to deliver a required notice or communication to the electronic mail address that a unit's owner designates and sets forth how an association must deliver such notices to an owner who has opted out of receiving electronic notices. The bill also provides that money in the operating account of an association may be withdrawn without the usual required signatures for the purposes of making automatic payments for certain costs. And lastly, it requires the Commission on Common Interest Communities and Condominium Hotels to adopt regulations establishing requirements related to the transfer of the possession of all books, records, and other papers of a client upon the termination or assignment of a management agreement. And as I said, there are no amendments.
Obviously, there are no amendments because, as we heard, this bill is perfect. And are there any questions on the bill? Not seeing any, I would accept a motion to do pass. All right, we have a motion from Senator Orenshaw and a second from Senator Wynn. Any discussion on the motion? Senator Hansen.
Thank you, Madam Chair. I am going to vote for it to get out of committee, but I will reserve my right. Just kidding.
All right, all those in favor, aye. Aye. Any opposed, nay? All right, it unanimously carries to do pass AB 309. Is there a volunteer for the floor statement? All right, Senator Hansen. And that takes us to SB 340. AB 340.
Thanks, Chair. All right. AB 340 revises provisions governing certain actions and proceedings relating to real property. This is a bill sponsored by Assembly Member Summer Armstrong and others. We heard it here on the 17th of May. This is the summary eviction bill. It repeals, reenacts, reorganizes, and revises a procedure for summary eviction of certain tenants who are guilty of unlawful detainer. The bill replaces repealed provisions with a new procedure for summary eviction, which applies to tenants who are not tenants of a commercial premises and who default in the payment of rent and who are guilty of unlawful detainer for reasons other than a default in the payment of rent. It provides that the landlord, upon the expiration of certain notice provided to the tenant, must apply by affidavit of complaint for the summary eviction of the tenant and serve the tenant with a file stamped copy of the affidavit of complaint, a copy of the summons and certain notice. If a landlord does not file with the court proof of service of the affidavit, summons, and notice within 30 days after the affidavit of complaint for summary eviction is filed, the court is required to dismiss the action for summary eviction. The tenant is required to file an answer to the affidavit of complaint within 10 calendar days after the date of service. If a tenant files an answer within the prescribed period, a hearing is held. If no such answer is filed, the court is authorized to order without holding a hearing the removal of the tenant within a prescribed period. The bill also requires a court that grants an action for summary eviction to automatically seal the eviction case court file under certain circumstances, and further, a court is required to automatically seal the eviction case court file for an action for summary eviction brought pursuant to these provisions if the landlord fails to file an affidavit of complaint for summary eviction within the time prescribed. There is an amendment that was offered during the hearing on the bill from the Nevada Coalition of Legal Services, which is a friendly amendment that the sponsor is happy with. It's attached to review, and this amendment makes several technical corrections, including deleting language from the bill relating to commercial tenants as appropriate, providing copies of various documents and notices to interested parties as appropriate, and adding clarifying internal statutory references. That's it, Chair.
All right. Any questions on AB 340? Not seeing any. I would accept a motion to amend and do pass. All right, we have a motion from Senator Wynn, a second from Senator Orenshaw. Any discussion on the motion? Senator Stone.
Thank you, Madam Chair. I regret, as most of you know, that I have to oppose this. I think the summary eviction process is fair both to the landlord and the tenant. And another reason is it will make a lot more work for my property manager, who is my wife, who just surprised me by walking through the door a few minutes ago for our 22nd anniversary. And this is my wife, Regina Stone, my property manager, who joins us. First time she's been here since we were sworn in. And don't want to make more work for my wife. So for those reasons, I'm going to vote no.
All right. Any other discussion? See none. All those in favor, aye. Aye. Any opposed, nay.
Nay.
Sounds like nays are Senators Stone, Krasner, and Hansen, and the measure passes. I will assign the floor statement to Senator Orenshaw. And that takes us to AB 452.
Thanks, Chair. Assembly Bill 452 is an Assembly Judiciary Committee bill. It revises provisions relating to visitation with offenders in a correctional institution or facility. We heard it here on May 16th. It requires the Director of the Department of Corrections to adopt regulations to establish and govern a program for the visitation of offenders. The bill further requires a warden or manager who denies a prospective visitor to provide written notice of the denial that includes certain information. The department must establish a panel to review such denials upon appeal of a prospective visitor. There is an amendment that was offered by Jody Hawking of Return Strong in consultation with Director Zarenda of the Nevada Department of Corrections. It is attached for review. The amendment requires that the Nevada Department of Corrections adopt new provisions governing visitation and requires that the Attorney General establish the Office of the Ombudsman, including provisions for the duties and the operations of the Office of the Ombudsman. And that's all.
Any questions? Yes, Senator Krasner.
Thank you, Chair. I spoke to Director Zarenda immediately after the hearing on this bill, and he told me that most of this language was already in another bill that we heard, and that this was going to be amended so that it only included the ombudsman position. Was that amendment ever agreed to or accepted?
Can you repeat your question one more time? I'm sorry.
After the hearing on this bill, AB 452, I spoke to the director of the Department of Corrections, James Zorinda. He told me that the majority of the language in this bill was in another bill that we already had heard. And he said that this was going to be amended to only include the ombudsman position. Is that correct, or has that been accepted, or was that amendment given?
Sorry, I understand what you're saying now. So we did have other bills on visitation. I've also talked to Director Zorinda about this bill. And the amendment here would remove instead of putting the visitation policy directly into statute, what the amendment does is says that the visitation policy has to meet these 3 requirements that are spelled out in the attached document. So it still has 2 parts, a visitation part and an ombudsperson part. And it is my understanding that the director is on board with this. And we can get him or a representative on the phone or down here if you'd like.
Thank you. No, that's fine.
Okay.
Thank you.
And I see the sponsor or the presenter giving us the thumbs up as well. So I think we are good. Any other questions? All right. Not seeing any, I would accept a motion to amend and do pass. All right. There's a motion from Vice Chair Harris, a second from Senator Orenshaw. Any discussion on the motion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. All right, we have 1 nay from Senator Stone. The motion carries to amend and do pass. And is there a volunteer for Senator Wynn? You will get the floor statement. And that takes us to AB 454. Before I turn it over to Mr. Guinan, there have been developments in the building today, and I would like to withdraw my amendment.
All right. As the chair just noted, we're on Assembly Bill 454. There is an amendment listed in the document which no longer applies, so this is a do pass motion for this bill. AB 454 revises provisions relating to legal services for indigent defendants. It was an Assembly Judiciary Committee bill. We heard it here just yesterday, so I'll go through it quickly. It revises provisions relating to the payment of compensation and expenses for attorneys who provide legal services to indigent defendants under certain circumstances. The measure provides that the compensation and expenses of an attorney are an obligation of the county unless the county has transferred its responsibility or met the maximum amount to be paid for indigent defense services. Provides that the payment to the counties of amounts that are not an obligation of the county. And finally, the Board on Indigent Defense Services is required to adopt regulations establishing rates of hourly compensation for attorneys who provide certain legal services to indigent defendants. And that's all, Chair.
All right. Any questions on AB 454? All right. Not seeing any, I would accept a motion to do pass. We have a motion from Senator Wynn. A second from Senator Orenshaw. Any discussion on the motion? All in favor say aye. And any opposed, nay. All right, it passes unanimously, and I will take the floor statement on this one. All right, I don't think we were technically in a recess, but we were functionally in a recess. So we'll come back to order as much as we're ever in order. And go to Assembly Bill 231 on the work session. You do have an amendment in front of you that was inadvertently excluded from the work session document. And you also have an amendment explanation from the bill sponsor. The explanation is the one that looks like an email. The amendment is the one that looks like an amendment. And I will hand it over to Mr. Guinan to go through the work session document, and then we can go over any questions.
Thanks, Chair. Pat Guinan for the record. Assembly Bill 231 and its first reprint is sponsored by Assemblywoman Baucus. We heard it here on the 26th of April. It enacts amendments to the Uniform Commercial Code, which is a set of uniform laws governing commercial transactions. Among other things, this bill revises provisions related to various emerging technologies, including transactions involving controllable electronic records, electronic payment rights, chattel paper, and controllable electronic accounts. The amendment that you have before you amends Section 25 with a revised definition for money, and it reads, money, quote unquote, means a medium of exchange that is currently authorized or adopted by a domestic or foreign government and is not a central bank digital currency. The term includes a monetary unit of account established by an intergovernmental organization or by agreement between two or more countries. And I'll leave the rest of the explanation to the sponsor, perhaps. Or
All right, any questions on the bill or the amendment? All right, not seeing any, I would accept a motion to amend do pass. All right, there's a motion from Senator Wynn, a second from Senator Orenshaw. Any discussion on the motion? Senator Hansen.
Thank you, Madam Chair. The amendment may have alleviated some of our concerns, but I'm going to vote no and reserve my right on the floor at this point. Thank you.
Senator Stone.
Could I just say ditto?
You sure can. And Senator Krasner.
Ditto.
All right. Not seeing any further discussion. All in favor of amend and do pass on SAB 231? Aye? Aye. Any opposed, nay? All right, the nays are Senators Stone, Krasner, and Hansen. The motion carries, and I will assign the statement to Senator Orenshaw. That takes us to AB 414.
Thanks, Chair. Assembly Bill 414 was one of the ones on the consent calendar. There are no amendments with it. It's also sponsored by Assemblywoman Baucus. We heard it here on the 3rd of May. It revises provisions governing powers of attorney. The bill establishes a form to create an advanced healthcare directive and repeals the current form for powers of attorney for healthcare. It revises provisions concerning witnesses to a principal's signature of a power of attorney for both healthcare, and removes the requirement that a certification of competency must be attached to a power of attorney in certain circumstances.
All right, any questions on AB 414? Not seeing any, I would entertain a motion to do pass. All right, we have a motion from Senator Wynn, a second from Senator Stone. Any discussion on the motion? Not seeing any. All in favor, aye. Aye. Any opposed, nay. All right, the motion carries, and I will assign the floor statement to Senator Harris. And that takes us to AB 444.
Okay, Assembly Bill 444 is a bill that revises provisions concerning child welfare. It's also sponsored by Assemblywoman Baucus. We heard it here on the 3rd of May. Assembly Bill 444 codifies into state law various provisions of the Federal Indian Child Welfare Act. It was enacted in 1976 to protect Indian children from removal from their homes and families and gives Indian tribes jurisdiction over the Indian children within their tribe. This bill establishes various provisions governing proceedings related to the custody, adoption, or protection of Indian children or the termination of parental rights to provide additional protections for Indian children in state law. The bill requires the court administrator and the Division of Child and Family Services of the Department of Health and Human Services to submit biennial reports to the chairs of the Senate and Assembly Standing Committees on Judiciary containing certain data relating to Indian children in dependency proceedings. Assemblywoman Bacchus offered an amendment at the bill hearing that is attached for review. The amendment adds new language where appropriate to indicate that sections 2 through 38 and 42 through 50 and sections 57 of the bill do not apply to certain proceedings involving a parent of an Indian child voluntarily terminating his or her parental rights and an extended family member subsequently adopting the child. And I understand there may be another amendment that the chair wants to discuss.
Thank you, Mr. Guinan. Come on up, Assemblywoman. I think that you were going to make a clarification on the record about the amendment and a potential additional amendment. Please go ahead.
Thank you, Madam Chair, and thank you, this committee and Chair, for your courtesy in working through this. We've had a lot of negotiations on this bill, and we do want to continue with the conceptual amendment submitted. In addition, we would like to add situations where we have surrogacies and we have confirming adoptions. Those should likewise be excluded from the provisions set forth in the bill, and I think it's like sections 2 through 38 or 39. Hopefully I captured that correctly.
All right, any questions? Not seeing any questions. We will move to, I will accept a motion to amend and do pass. All right, we have a motion from Senator Wynn, a second from Senator Don Darrow Loop. Any discussion? Not seeing any. All in favor, aye. And any opposed, nay. All right, the motion carries and the bill to amend and do pass. And I will give the floor statement to Senator Wynn. And I believe that takes us to the end of our work session. I didn't miss anything, did I? All right. That takes us to the end of our work session. We have a couple more things on, well, really only 2 more things on the agenda today. We have public comment. Is there anybody wishing to give public comment today? Come on up.
Tanya Brown, TONJABROWN, Advocates for the Inmates and the Innocent. We would like to thank you very much for passing these bills. Although our amendment did not get into AB 49, we are hopeful that in the future that you will finally accept and allow the opportunity of those who have been wrongfully convicted, the opportunity for their families to exonerate their names. And again, thank you so much. You guys are one of the best committees that we have seen this year. And usually you're a little stuffy, but you know. Good job.
Thank you. I don't see anybody else to give in-person public comment. Is there anybody on the phone?
Thank you, Chair. If you would like to offer public comment today, please press star 9 now to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT. The families of those who have died in Nevada prisons wrongfully convicted have been and continue to be harmed when it feels like the scales of justice will never be balanced towards justice for their loved one in Nevada. If Nevada continues to have no mechanism for those families to have a fair judicial review of the case, their hopes for justice are dashed and negatively impact their psychological healing when there is no remedy. The Washoe CI Conviction Integrity Committee unit has shown they will not conduct a fair review when prosecutorial misconduct is alleged in the review request. Exculpatory evidence not presented at trial due to the prosecutor withholding it from the defense is simply ignored by the Washoe County CIC unit when they are presented with it. Essentially, it's the fox guarding the hen house. I say this with sincere conviction because if the Washoe CIC unit were seeking true justice, Mr. Nolan Klein's review would not have been the dog and pony show it was. Thank you.
That concludes callers for public comment.
All right. You've probably seen a number of committees today thanking all of their staff and talking about how wonderful their committee experience has been this session. And here in Senate Judiciary, we're actually not done. We are going to have at least one more bill, so we're going to have at least one more hearing. You may have heard of a little thing called medical malpractice that's coming over to our side. So I don't think I let the cat out of the bag on that one. Of course, the schedule is now subject to all kinds of new and exciting changes, so I can't tell you exactly when that hearing will be, but we will all be together once again next week for a hearing. But there is one person in the room who I'm not sure will be joining us again for a while, and that is our amazing, incredible, super fantastic secretary, Pat Devereaux. And she has been doing this for, I think, 10 sessions, 8 years since I've been here. So she has helped me out when I was, first getting started. She gets our minutes out on time. She keeps us moving along. She is a pleasure to work with. I always enjoy running into her in the hallway in the morning, and she greets me, and we have a little chat. And it's just been such a pleasure to get to work with the best staff in the building, and she is one of those members. And don't worry, we will talk about all of you at our actual last meeting. And I just wanted to thank Pat and give her a little round of applause. So, unless anybody else has anything, until that mystery meeting next week, we are adjourned.